comes to my mind is that we need to get things right, and for the bar to know that we are in transition, and that we need to transform, and that credible, strong, vibrant institutions are necessary for that in that process. We are on the right track.
Your Honor, would you say that the efforts that have been put since inception to structure Nigeria's judiciary are commensurate with results that we are seeing? It's the 58th Annual General Conference of the Bar.
Well, the bar or the Nigerian judiciary is not an island. It's part of Nigeria. So whatever problems or issues that abound in Nigeria are bound to reflect on it. Am I happy with the state of things? Who is? We all want to move further and higher and better. So that's what we're doing. We're going to move. And one thing I know is that Nigeria is going to move on and break whatever jinx others think it has and be a great nation. That's our destiny. I have no doubts about that.
One of the highlights of the first panel session this morning was when a delegate, stood up to cite his confusion in court about the definition of the rule of law as far as Nigeria is concerned on one hand, and on the other hand as far as the Nigerian bar, the judiciary, is concerned. And he cited the president's statement about the position of the rule of law vis-a-vis what the judiciary stands for when it comes to defining the rule of law. Is there a confusion in this area, or is this just sentiment?
I say, I'm glad. Honesty is the best policy. When you ask me how long have I been around, and I answered you honestly, this is my first day, I'm glad I did. I missed all these sessions that you're talking about. I only came for my own session, and so, having not had any of them, as a lawyer and a judge, I'm not going to pass judgment.
Is there a confusion on the definition of the rule of law as far as the judiciary is concerned? Can it be interpreted in different ways? When it comes to national interest, does it mean something else? When it comes to individual interest, civil cases, criminal cases, arbitration, does it mean different things in different situations or scenarios?
Every term, terminology, or word can only be understood properly within a context. I'm not availed of the context of the discussion, and I'll be misleading you by offering you an opinion.
So let's talk about your expectations at the end of this conference.
Yes, my expectations at the end of the conference is that the lawyers who I'm following and chasing all over to go and subscribe to the legal email to buy into our technology project so that the Nigerian judiciary can automate and serve Nigeria better so that we can deliver justice speedily, efficiently. That is my goal. I hope we get the uptake. Right now, we've got lots of things lined up to improve justice sector delivery, but we need to onboard the lawyers for them to have their digital identity through that at nigerianbar.ng before we roll out to e-filing and so many other things that we believe we are going to set the pace, not just in Africa, but in the world. Like, for example, already we are the first to leverage blockchain technology. For
say judiciary in Nigeria and the technology, that is a first.
Yes.
What informs that, and how is it expected to work out?
It's simple. Internet is the digital age.
It's been around for a while. The judiciary is only just latching onto it.
Exactly. Unfortunately, we are not, as judiciaries go all over the world, we are not even laggards. We are at the forefront. If you're been at my presentation, and if you were not, look for it, you will see other nations have come. We hosted 5 chief justices of the Caribbean nations who are even close to the US, and we're using a system developed and deployed in the US. But when we developed ours, they realized ours serves them better, and they came. So we are not late to the game. Actually, we have no business even saying that. We must be leading it. We've got all the talent, resources, everything that is needed for an effective digital age judiciary and legal system in this country. We can't just wait to unbind. That's what I'm telling you.
Okay, my final question to you, Your Honor. You hinted earlier at efforts at restructuring the judiciary when you were referring to technology. If you're able to, at this point, elaborate a bit more on that, I would really appreciate it, the steps you're taking.
Yes, it's not the judiciary we are restructuring or aiming to restructure, but our own processes, the way of doing business. moving away from manual and paper-based processes to the electronic platform that becomes speedier, cheaper, more effective, more efficient, particularly as far as the ordinary man and the litigant is concerned, time-saving, time-saving. We waste a lot of time arguing whether a lawyer has been served, whether there is proof. With this technology, it's instant, real time. The judge will click on a button and he knows you've been served, you can't deny it.
Will this resolve how long it takes for a case to sit on the desk of a judge and the law courts,
exactly.
the adjournments?
Thank you very much for that question. Cases actually don't sit on the desk of the judge. The judge is always there in court waiting, but it's always, has this lawyer been served, or has the other lawyer been served? Has he been told to come? If you've not told your opponent to come to court, you can't move on without him. I assure you, more than 50% of the delay we experience is because of this. And with this deployment of the legal mail system, we are going to save more than, because it's the Pareto principle. It's 50% the cost, but by the time you solve it, the benefit you're going to reap is about 70% of the delay will be cut out. And then now coupled with our case management system, which is also in place, and we're now uploading all cases, backlog of cases, you'll be surprised how quickly we overcome all this, and then we'll be celebrated.
So delay is as a result of communication?
Communication problems. Thank you very much.
Who's dropping the ball?
Wow. It's the manual, it's the process itself that's responsible. There's no point blaming anybody for a system that doesn't work. You give a man a donkey and tell him to reach Lagos in 2 hours. He can flog the donkey as well as he wants. That donkey cannot reach Lagos from Abuja in 2 hours. He can end up killing the donkey. So manual processes, paper processes are donkeys. All we've been doing has been flogging them. They can move faster.
So how long before we expect to see implementation and results?
It depends on the buy-in of lawyers and the uptake. It's something that can be done within a week, but then the more lawyers on board, the easier it becomes. Because that way you don't even need to know the lawyer's address, email address. As soon as you type in into the system, it has an internal directory whereby you can serve him. So nobody hides and avoids service. I'm sure you are aware of some of these antics. So many of things, so many of these antics will be eliminated, and that's where we intend to make a lot of progress.